there was a sweeping bankruptcy settlement that was at issue before the Supreme Court. The Supreme Court now has rejected that nationwide bankruptcy settlement with the OxyContin maker, Purdue Pharma, saying here ultimately that it was not fair to a subset of the victims who did not agree with the settlement, the so-called third-party entities here in this case. A lot of the victims wanted to pursue this settlement, which exempted the Sackler family personal billions from the reach, really, of the victims here. Some of the victims did not want to do that. The Supreme Court here saying that the settlement cannot speak for all of those victims in that particular way. They say it's a narrow decision, and part of the reasoning here is the flow of money from Purdue Pharma to the Sackler family, and then whether or not that money ever goes to the victims. The Supreme Court outlining the events here, saying fearful that litigation would eventually impact them directly. The Sackler family initiated a milking program, withdrawing from Purdue Pharma approximately $11 billion, roughly 75% of the firm's total assets, over the period of a decade ahead of litigation. They say the Sacklers proposed to return approximately $4.3 billion to Purdue's bankruptcy estate. And in exchange, what the Sackler family wanted here was a judicial order releasing the family from all opioid-related claims and enjoining victims from bringing such claims against them in the future. The Supreme Court here, Carl, is now rejecting that deal.